without much further ado, let me introduce our first speaker, hoping that all our speakers would have joined us. I will just make a check in a bit. And our first speaker is Dr. Elisa Ortega Velázquez, who is a tenured professor at the Institute of Legal Research of the National Autonomous University of Mexico, UNAM. She holds a PhD in law, and she has a Master of Laws from the University Carlos III of Madrid. I was going to attempt to say that in Spanish, but I think all my basic Spanish escapes me. But her research focuses on asylum and forced migration of children in Central and North America. So we'll hear a lot about that perspective. Dr. Elisa, would you mind to just take us through and give us sort of a critical view, in your opinion, of some of the gaps and the challenges that you see in achieving international cooperation for us to realize this global objective number 8 of the Global Compact of Migration. Over to you, Dr. Elisa.
Okay, hello everyone. Thank you, Paddy. First of all, I would like to say that Objective 8 contains 3 main elements: saving lives of migrants and preventing their deaths and injury, the identification of the missing and the dead, and the provision and assistance to their families. Thus, through this objective, states have formally recognized that in embarking upon migration journeys, people's lives are put in jeopardy every day, and many go missing or die as a consequence. However, the responsibilities of states in this regard are not new. Rather, they have long existed and can be found within established international law. For example, the Universal Declaration of Human Rights states in Article 3 that everyone has the right to life, liberty, and security of person. Also, in Article 14, the Declaration acknowledges the right to seek and enjoy asylum from persecution, which is further developed in the 1951 Convention relating to the status of refugees. Also, the International Covenant on Civil and Political Rights recognizes in Article 6 the right to life and the duty to investigate. And also, the UN Convention on the Law of the Sea establishes in Article 98 the duty to search and rescue. But migrants and asylum seekers do not die by accident. Evidence suggests that multiple failures of states to respect and protect the right to life, such as unlawful killings, the excessive use of force, and deterrent policies and practices, have had as a result the increment in the risk of death. National responses to migrant deaths have mainly been determined by tighter border control policies and anti-smuggling strategies, but little attention has been paid to the respect owed to the dead and the missing and protection of their bereaved family members, so as to ensure that already traumatic experiences are not made worse. The names of most of the dead and missing are not known. Their families have not been traced, and where bodies have been found, they are often piled in makeshift morgues or buried in unmarked graves. Families have no answers to what happened. They don't know if a missing relative is alive or dead. Thus, unnecessary pain and suffering of migrants and their families are regularly a result of inadequate or even antagonistic state practices. For example, Italian government refusal to allow rescue migrants to disembark. US legal sanctions for activists who provide water to regular migrants crossing the desert near Arizona in the US-Mexico border. Mexican government's failure to investigate and provide justice to the families of the 72 migrants killed by the organized crime 10 years ago in San Fernando, Tamaulipas, Mexico. And in general, the prosecution of civil society humanitarian actors for provision of food, water, shelter. So Objective 8 recognizes that it's not solely the criminalization of the humanitarian assistance that undermines the rights of migrants, but the deliberate and disproportionate use of civil law and legal obstacles to render humanitarian assistance unlawful for non-compliance must also be prevented and addressed in a much more cooperative way, both at national and international level. Unfortunately, international cooperation has proven to be unsuccessful in these terms, but fruitful when it comes to divert asylum seekers from poor countries through safe third country agreements. For example, in 2019, the US signed 4 agreements of this type with Mexico and 3 Central American countries, Guatemala, El Salvador, and Honduras, 4 countries which cannot be considered safe for asylum seekers, and furthermore, these countries produce forced migrant and asylum seekers. Death and distress do not distinguish between those embarking by choice on migration journeys and those who are forced by persecution, conflict, violence, or other circumstances. But both frequently occur as a consequence of forced irregular migration in the absence of lawful modes of migration and very restrictive asylum systems and more in COVID times. Artificial distinctions and barriers based on the immigration status of missing, deceased, and buried persons must not be erected when addressing the legal and practical issues of search and rescue. The treatment of missing persons, the management of bodies, and all the duties owed to the deceased and their families. International norms do not directly address the rights of those who died or go missing at international borders and of their families. There is an assumption that human rights end with death. Where legal rules addressing the treatment of the dead or the missing exist, they do not directly apply to a particular context of irregular migration and border deaths. Also, there is no provision calling on states to enable the movement of bereaved family members across borders to participate in identification, participation at the inquest, and other coronial procedures, legal proceedings, burial, and paying respect. There is no provision for the states to establish annual budgets and funding for welfare, psychological, and advocacy support for bereaved families, with a special provision for children, and nothing exhorting states to make legal aid available for their participation in proceedings related to the death or disappearance of their relatives. So there's a lot of international action to do, and I would like to finish with this.
Thank you, Dr. Elisa, for that. I would just come back to you later, maybe after our second speaker has spoken. You do mention there the importance of family involvement in terms of identification of bodies, and I just wanted to find out if there was any examples that we have from the regions that you cover that has shown, that has shown maybe even at a local government level, if you like, administrative passes or administrative means that allow families to participate in the identification of the deceased. So I think I would come back to you on that in terms of understanding that, and also maybe to get a sense from you what would be sort of the reasons that are being attributed to this lack for countries that don't allow that identification to take place as a means to support the identification process, rather. What are the kind of reasons that are given to deter families, and also to understand a bit more about what kind of other practical support that's given to families in this case for them to have closure over their deceased relatives. So